First of all, can anybody say that this committee has given a clean chit? Is that even a right statement?
See, don't forget about what contains in the report. Forget that. It is only a status report. It's not a final conclusive report.
Namaskar. A 6-member committee was appointed by Supreme Court basically to probe allegations of stock market manipulations and regulatory failures in dealing with allegations against Adani Group. 6-member committee was appointed. Now, the 6-member committee consisted of Justice J.B. Devgar, retired, K.V. Kamath, former MD, CEO of ICICI Bank, O.P. Bhatt, former chairperson of State Bank of India, Nandan Neelakani, chairman of Infosys, and lawyer Somashekara Sundaresh. So this was the 6-member committee, and this 6-member committee gave a 173-page report to the Supreme Court. Now, the interesting part is right after this report, a lot of media, including NDTV, started reporting that, you see, this committee has given a clean chit to Adani. Now, there was a lot of confusion. Confusion, as if when I read that report, whatever little I could understand, I never saw anywhere where the clean chit was given. So that was the first confusion. The second confusion is, bhai, ye committee kya hai? It is the Supreme Court had asked SEBI to investigate, then this committee. So what is this committee? Is this committee different to SEBI? Is SEBI different to the committee? So there was a lot of confusion. And therefore, to sort all this confusion, I invited Advocate Viplav Sharma and primarily trying to understand, sir, from you, as always. Sir, last time also I had called you when I was in confusion. That was regarding the Maharashtra, if you remember. This time also I am confused. So I have come to you for aid. So, sir, what is this confusion? Why is this committee? What is this committee? What is the role of this committee? And what is the role of SEBI? SEBI was asked to investigate, or is this committee asked to investigate? What exactly is this? What exactly is this confusion?
See, all this thing got triggered pursuant to that Hindenburg report, and few of our public-spirited persons or lawyers, they approached Honorable Supreme Court by way of PIL writ petitions under Article 32 of the Constitution, and raised the issues which were possibly guided by the Hindenburg report, which prima facie or allegedly reflected against the wrongful business approach by Adani Group to the extent of, at great length, to the extent that most of the Indian citizens were affected by it. So therefore, they requested the Honorable Supreme Court to be seized of the matter and see what is all about, and to see that the public at large is, communicated the transparency of all the affairs which has been highlighted by Hindenburg, or to be seen by SEBI or other regulatory authorities to have been missed on such things which have been highlighted by Hindenburg report. So that was all about. So when the matter went to the Supreme Court, the Honorable Supreme Court, because it entails complex financial issues, so an idea was brought to the central government during the first hearing or maybe second hearing, that what if a committee is constituted to deal with the subject matter, which is being seized by SEBI as its regulatory part of job under the legislation, or other statutory authorities, to examine it properly and to see exactly whether there have been laches or negligence, or everything is honky-dory, everything is fine. It is only basically the Hindenburg report for achieving its whatever purpose it has, which everybody knows, it's that basis because of which everything is being highlighted. Now, thereafter, I think so, without there being any objection, or what all has possibly transpired behind the curtains, the Supreme Court then pushed the proceedings in a manner to see that they deemed it appropriate to have a committee of experts. So that committee comprised few of the financial consultants who are financial professionals and have achieved landmarks in their respective fields, to be headed by a judicial mind, which is a retired Supreme Court judge, Justice Sapre, made the head of the committee. He is from MP High Court, and he got elevated to the Supreme Court. And then, after he was retired, this assignment was requested to him, and he was made head of the committee to have a judicial mind to what all the committee is presented by SEBI or other regulatory authority, primarily SEBI, because it deals of the allegation was that there was wrong things happened in the stock trading and the functioning of the companies, which is purely within the domain of the SEBI. So therefore, the Supreme Court, while constituting this committee, took a note of the SEBI's investigation of what all it was informed by SEBI. But while prima facie observing that not only what you're doing, maybe something or other things are required, you do that also. And then you have to, your work will be seen by this committee. And committee was assigned the agenda in after para 14, where it was constituted in that order of February 2023. And they were also given their role as to what they have to do. And if that role, if you see, is only to, it's kind of an audit role, what all is being done or presented by the SEBI, they will examine it, and if there are any flaw or anything, you will come out with a suggestion how to improve on it, how to take care of things in future, and so that these things are not repeated. But subject to correction, and if I misses it, I don't think so that that scope of work of the committee identifies anywhere that in case if any wrong has been done, which is entailing the criminal law to be triggered or any penal consequences, so to speak, you will also advise that how that can be remedied. Because it's a financial matter, so it's not allowed to, if you see criminal breach of trust under IPC, 406 is normal criminal breach of trust, but 409, which it entails to a merchant or a banker, which involves a finance, then the punishment is more rigorous, it's 10 years of life imprisonment. So you can't play around with the funds of common man or country or a state exchequer, or of an institution which is purely governed under the legislation by the central government or the state government. For example, State Bank of India is governed by State Bank of India Act. LIC is governed by LIC Act. Every business has to be done, the stock business to be done by SEBI, which is also constituted by law. So there is no play available for you to do anything unless the institutions which are governed by the legislation, where the legislature provides the limited scope of each institution working, and no leverage is given to any institution to go haywire to make such kind of investment which they have done in this any case.
Mr. Sharma, then I want to ask you a simple question, which is, in my mind, I understand that this committee is supposed to be a consultant to the Chief Justice, to the Supreme Court. My apologies. They are supposed to consult the Supreme Court, correct? Is that right?
No. When the committee was formed, the committee was formed after taking the stock of the situation as was presented at the time of filing of the writ petition before the Supreme Court. And at the time the Supreme Court was alive of this information, that Hindenburg report is already been released, and there is chaos everywhere throughout the world, particularly in India, because Adani hails from this country. So therefore, some part of the work is being done by SEBI in that behalf. So that was brought to the notice of the Supreme Court. But Supreme Court, since the petitioners, they were asking many prayers. One was asking that constitute a committee, so we are not presided by a retired Supreme Court judge, or appoint an investigating agency to see what wrong has been done. So there are few prayers. So they needed to address those issues of the writ petitioner to see the logical conclusion to the whole issue. To facilitate for their effective adjudications, they deemed proper to have a committee of the members comprising of the respective field which were required to investigate into the matter by
to advise the Supreme Court, right?
Yes, to assist the Supreme Court. Yes, to assist the Supreme Court. It's something like this. Something like amicus to the Supreme Court.
Correct.
I mean,
that's what I meant by consultants to that extent. Okay. So that's what I understand that. Do they have any authority by any chance in any form?
What kind of authority you are referring to?
As in authority of accusing or authority of giving clean chits. Do they have that authority?
No. See, they have to just comment on. See, they have to review the investigation done by the SEBI or inquiry or processing of the issue done by SEBI, which is also made subject to the proceedings of these matters before the Supreme Court. So earlier they could have said something and have gotten away with it. Now, by putting this committee on their head of SEBI, so the Supreme Court is actually monitoring it through this committee. Okay. Now, but it will depend. But still, whether the scope which has been designed for this committee actually addresses the issue raised by the petitioner is a question one had to go into it. Because they have asked many things. They have, all the PIL petitions, according to my opinion, they are the whistleblowers. So this is what is happening. Now we are bringing it to your lordship notice. Kindly do something about it. So therefore, once something alarming thing has been presented to the Supreme Court, and since it entailed a large sums of funds or money, so on the spot, the Supreme Court would not go as whatever the petitioner is saying. We're talking about the business of thousands, lakhs and crores by one of the entity which has been made subject matter of the petitions. But at the same time, since it entails the public exchequer, it entails the public funds, it entails the financial interest of the common man, it cannot be disregarded. So it has to be, this whole issue has to be addressed a most scientifically and most effective manner. So they thought that the whole issue of the corporate business mechanism, which was being done by Adani, is not hush-hush business. Wherever you're having the companies, whether in India or overseas, you need to disclose it. So therefore, SEBI is an expert body to see whether you are in compliance with all the rules and regulations of the regulatory authorities which is involved in the matter. And if it is not, then to what extent the breach has been committed and whether it is so severe that the penal consequence to be there, or it is it has to be improved or corrective measures to be taken place. Now, in order, since SEBI is there, again, government department, nothing is hidden. Who is Mr. Adani? How the huge size of business is going? So, according to my opinion, the honorable judges in their judicial wisdom thought that let there be a independent transparency in this. So they got this committee into the affairs, and the committee has to see it. But the problem where I see it is that not only once this whole issue is there, one agenda ought also be there that in case if there is a wrong to the extent where the criminal law gets triggered, so therefore that issue ought also have to be incorporated. Maybe it may incorporate in subsequent proceedings. We don't know, because we can't just say that these things were so unlawful that it entailed criminal law into the situation. Maybe it may come in further. But currently, as I see the order, as I see the scope of it, it's there that what all the SEBI is doing, they will go into it and they will make a report of it, and then they will place it before their lordships for lordships consideration to adjudicate those petitions where the prayers are of different kind. Maybe one or two prayers are different kind. So this is where it is. Now, coming back to this report, everybody know that they wanted more time. This is kind of like once you register a FIR, the police on each end, if that FIR is challenged or if it comes to the court, then the status report is being filed, that what investigation has taken place by the cops, and that status report is placed before the court, and then court on the basis status report takes a call on that date of hearing. That's how it goes. So this thing they were asking to, because at the time of constituting the committee, tentatively I think so 2 months was given to do the investigation, but it was too short a time, not adequate time for dealing with this mass subject. So possibly,
Mr. Sharma, I need to intervene for a second. This 2 months were given to SEBI to investigate Adani, correct?
Under the supervisory authority of this committee.
Of this committee, correct. So 2 months was given to SEBI to get back to the Supreme Court with a report, which SEBI asked for another extension of 6 months.
Yes.
To which Supreme Court says, we will not give you 6 months, we can give you 3 months. Maximum, if you have a problem, we will give you 1 more month of extension. This is what Supreme Court says.
I'll like to say something on this. See, once this committee got in place, so now the committee is merged with the SEBI investigation. So what all report either the SEBI is giving to the committee or committee takes it and puts it before the Supreme Court is one agenda.
Okay.
So what I'm trying to say is that whether assuming SEBI would have done the investigation, assuming, for example, they would have concluded it. That now we're closing it. These are our results. This is where we're closing it. And then they had to give it to the committee as per the order.
Correct.
Now the committee has to see all those parameters which their lordship has been pleased to identify, has been addressed by SEBI in its report, which it is given. And that's not one day job. They have to apply, each 6 of the members will have to apply their mind to ask the very question, because not that report, what all, either given by SEBI or that gets culminated by the executive report, placed before the SEBI will, and as such, then it will be given to the other side. They will drill holes in that this is where you missed out, this is what you did not do, this is the process you had failed and neglected to do it, you did not check the, besides violation of 19A of the regulation part, contract regulation part, where minimum 25% has to be maintained, the funds which have been infused by LIC and SBI could not have been done under the respective statute, that you did not take into consideration. So it's not a one-day job. So either they're doing it directly or they're giving and routing through the committee. The whole thing with the issues identified by the Supreme Court has to be placed before their lordships.
Correct. So, sir, now let's get into some pointed questions. Let's understand. I got the process.
I'm talking about my opinion. This is how I'm seeing it.
Yeah, absolutely. So I got that process. Now, sir, tell me, in this report, first of all, can anybody say that this committee has given a clean sheet? Is that even a right statement?
See, don't forget about what contains in the report. Forget that. It is only a status report. It's not a final conclusive report.
Correct.
So what all it contains is just during this time, they got to know these things, and those things, whatever they got, which they presented in 173-page document, we do not know that what you missed deliberately or otherwise, or what you ought to have taken is not been taken, missed out, or you will take in your further course of action. We don't know. So that's what their lordship has been pleased to. If you allow me, I just read the relevant line of this order, 17th May order, Monday order. The first 2 paragraphs says it all. It says the expert committee has submitted a report bearing in mind the timeline of 2 months stipulated in the order constituting the committee. In order to enable the court and council to analyze the report and reflect on suggestions which have been made by the expert committee, the proceedings shall be listed after summer recess on 11th July 2023. The expert committee is requested. Now, this is important. The expert committee is requested to continue to assess the court. The committee may hold further deliberations in the meantime. The committee would be requested to take up any further aspects or suggestions as may be formulated by the court following the course of deliberations when the proceedings are next listed for hearing. And the copies of the report of the expert committee shall be made available to the parties and their counsel to enable them to assist the court in the course of further deliberation the registration takes. So what I'm saying is this is conclusive. This is
So saying that the committee has given clean chit is misinterpretation of fact. Would you agree to me, sir?
according to my opinion, this is not a conclusive report. This needs to be deliberated. If the committee says that they agree with what all was provided by the SEBI, then they are subject to scrutiny by the court and by the other side. That what all you have missed out, what all you have not taken into consideration, or what all extra you have taken into consideration, which have led to this kind of a confirmation. So this is...
Sir, yeah, I'm sorry, I'm rushing because I've got 3 more minutes and I've got 2 very important questions to ask you. Sir, when you say that when the Supreme Court first gave SEBI 2 months to get back to them, yeah, then SEBI came and said, at that point in time, SEBI agreed. SEBI said, fair enough, we will come back to you in 2 months. Then they asked for 3 more months. Okay, which 6 more months, my apologies. Which Supreme Court said, no, take 3 months, or like I told you, take 1 more month. Sir, isn't the Supreme Court being over lenient here? Does this happen to everybody?
No, it may happen because the matter is such where you have to dig in lots and lots of data, information and all that. Sometimes you're asking for information, like if the document which you shared me, you don't get a response from the other side willingly or otherwise.
Wouldn't the SEBI...
I'll just add one thing.
Sorry.
Be that as it may, even if it is delayed, if an offense has been committed, it will still continue to remain an offense. So, extension of 2 months' time, 3 months' time is not going to camouflage the issue. It won't.
Sir, my question is very simple. Sir, my question is, doesn't the Supreme Court know that it will take more than 3 months or 2 months to get back with all the investigation? Doesn't the Supreme Court know? Is SEBI that inexperienced to accept 2 months and go back and then come after 2 months and say, I want 3 more months? Did the SEBI know at that point in time?
No, I'll respond to that. See, these are the areas which are on the field. These are not theoretical that you're writing a thesis will complete in 2 months' time and 3 months' time. These are the things which are based on several variable factors. The SEBI inquiry investigation into many other agencies, regulatory, private agencies, other agencies, stock market, and SBI, LIC, they're just doing an X-ray of the whole Gautam issue. So the parameters are not fixed. That you will, if I'm asking Sujit Bhai one question, you're going to respond me instantly. You will say, all right, I'll see, I'll have to examine my documents, I'll revert back to you.
Correct, sir. I still maintain my question that if I cannot answer you instantly, I will tell you, the moment you ask me a question, I will tell you, with whatever little experience I have, I will tell you, listen, I need 6 months, I cannot answer you in 2 months. My question is, after taking 2 months, asking for 6 months, that is India's foremost stock regulatory body. Don't they know that they have to have the investigation will be rather wide? Didn't they know that? Is my question.
I agree with you. Now I'll give you 2 sides of answer to this question. One, it is doable, it is possible, provided you have a zeal to do it. This is one part. But sometimes, considering the volume of the work, sometimes I even anticipate that I'll be able to finish it off in 2 months' time. Despite my best zeal, the other agencies who may not be sailing with my idea to immediately finish it off, who are inextricably linked with this inquiry, will not be so cooperative as are required.
Correct.
And my time limit is also based on their, cooperating in the inquiry. So
my last...
Let's give them the bona fide on this. Let's give them...
Yes. My last question based on what you just said, sir. It's your personal opinion that I seek based on your experience. Sir, in your personal opinion, do you think this investigation will be fair? Do you think this investigation will be done according to the way it should? And do you think that this entire thing this case will get a fair trial? What's your opinion?
Very small thing. The kind of stakes are involved, the fair inquiry will go whichever way is the answer. The
Correct.
stakes, the people involved, the power involved, and the way to camouflage and come out of it is also available by use of this time.
Thank you so much. Thank you so much, Sharma ji. Thank you so much for your answer.